The next hurdles you have to jump through is you have to meet an income test and an asset test.
Correct.
Can you first walk me through how does the income test work in Maryland, and is there one, and if so, are there ways to get around it?
Well, the income rule in Maryland is basically that you can get Medicaid as long as your income is lower than the cost of the nursing home. So given that the average cost of nursing home around the country is over $10,000 a month, and in Maryland, depending on what part you're in, I'm in the part that's in the suburbs of DC, the average cost in our area is $12,000 to $14,000 a month.
Wow.
Very few people have monthly income anywhere near that kind of the figure. So almost everybody qualifies based on income.
And if they do, they probably aren't looking into Medicaid.
Exactly. And the income rule is simply that if whatever your income is, at least for a single person, your income has to go to the nursing home as essentially your copay. It's called the patient pay. And there's certain deductions for that. There's a monthly needs allowance, and they let you keep enough to pay for your health insurance. But general rule, your income goes to the nursing home. Medicaid pays the rest. With married couples, the rules are different because we're able to shift income from the nursing home spouse to the healthy spouse, even under basic Medicaid laws. With more advanced planning, where someone would hire an elder law attorney such as myself, we can shift even a greater amount of income in many cases to the healthy spouse. As far as the assets, there is a minimal asset test for an individual to get Medicaid. A couple $1,000 for a married couple. The rules are, again, this is without using an experienced elder law attorney such as myself for planning. The basic rule is that Medicaid is going to look at all of the assets of the married couple as of what's called the snapshot date, which is the date that the person first goes into the hospital, which leads to the nursing home. The first time that happens, and they're in there for 30 days. That first day of that month is the snapshot date. They add up all the assets of the couple, regardless of how they're titled, jointly, separately, and they divide that amount in half. And the theory is that the healthy spouse gets to keep half of those total assets, but it's not really half because it's capped at a maximum, which is about $126,000. So that's without proper asset protection planning. With Medicaid asset protection planning done through someone like myself, we can protect essentially all of the assets of a married couple and get the healthy spouse, or get the nursing home spouse rather, on Medicaid, typically in 3 to 4 months.
It's phenomenal. So, and you started talking about the asset test and some of the issues there. I also want to just touch on some of the common assets that your clients typically own. The first one that comes to mind is real estate. Most people own a home. Some people also may have a vacation home or even an investment property. How does it work with real estate under the Maryland Medicaid asset test?
Sure. Well, the home or primary residence is treated differently from other property. With the primary residence, it is exempt for eligibility purposes, so long as someone signs a document saying that they intend to return home, no matter how impossible that may be. But just because it is exempt for eligibility purposes does not mean that the home is protected, because what Maryland Medicaid will do is they will slap a lien on that home, and that lien will be acted upon after the Medicaid recipient dies. Basically, when the home is sold, Medicaid is going to get repaid for all the money that they spent to pay for the nursing home care of the Medicaid recipient. So they're gonna claw back through the estate recovery program, and they claw back very aggressively because, unlike most states, they actually put a lien on the property, as I mentioned, during your lifetime, and so they will get money from the sale of the house. For other real estate, the laws are very different. Depends who owns it. If it's jointly owned, there's often ways to protect real estate that's jointly owned with another party. I mean, the general rule is it's all countable, whether it's jointly owned, separately, individually owned by the married couple. It's all countable, but with asset protection, using strategies, guided by an experienced elder law attorney such as myself and our firm, there are ways to protect investment property in many cases, and also sometimes avoid having it be subject to the estate recovery.
You raise a great point there, Evan. The first step, obviously, is with any of this planning is to ensure that the person qualifies for Medicaid coverage sooner. But obviously, you also want to protect as many of their assets as you can, and if you can protect against estate recovery and preserve those assets for their spouse or children and family, that's obviously a whole other level of planning, and it creates a much better long-term situation.
Right, and often we're not. The goal is not just to protect assets as an inheritance for the family, but the goal actually is more often, or equally as often, is to protect assets to make life better for the person who's in the nursing home. So in other words, the assets that have been protected can be used to make life better for your loved one who's in a nursing home, paying for things that Medicaid doesn't cover, such as replacing lost or broken eyeglasses, dentures, hearing aids, paying for better food to be brought into the nursing home, even paying for a private sitter if that might help someone who is, say, paralyzed from a stroke. A private sitter can be there to help read to the person, help turn on music, or turn pages on a Kindle, or turn on an audiobook, or change channels on the TV, or help the person to the bathroom every couple of hours so they don't wind up sitting in dirty diapers for 6 hours a day, which is sadly the fate of many people in nursing homes.
Can really make a big difference in the person's quality of life, it sounds like.
Exactly.
And then what about some other types of assets that people commonly own? I'm just thinking of retirement accounts or 401ks, life insurance policies, annuities. Are all these countable assets, or under Maryland rules, do any receive preferential treatment?
All of these are completely countable. With life insurance, of course, they only count the cash surrender value. They don't look at the death benefit. So term life would typically have no cash value and therefore not be counted. But any kind of whole or universal life, which has cash value, is going to be counted at the cash value. Retirement accounts, fully countable, whether they belong to the applicant or the spouse, whether they're taking required distributions or not, totally irrelevant. It's a liquid resource, and it's going to be 100% countable